And I'm just going to give an admonishment. I'm not making any accusations or anything. There are a number of people in the courtroom. Any outburst, anything will not be tolerated. You will be removed. If you keep giving me problems, you'll be taken into custody and there'll be no questions asked. I hope everybody is understanding.
I think everybody understands.
It does call the case of the people versus Fareed. Is it Hajar? Hajar? Hajar. All right.
Jessica Blanche, hearing the people.
Good afternoon, Your Honor. The court, please, Mark Krieg on behalf of Mr. Hajar.
And Ryan Murad, PA 3665 on behalf of Mr. Hajar, stand present to my right. Sir, please introduce yourself to this honorable court.
My name is Fareed Hajar.
All right.
I would give my P number, but I don't want anyone knowing how old I am.
They didn't have them then, did they, sir? No. everybody knew each other.
My partner, he started when there was no P number.
Got it. All right. This is your motion. He can have a seat.
Thank you, sir. I have filed a brief, but I have some supplemental information.
Yes.
I provided the court with a letter from his employer. Did the court receive that? I'll give it to Ms. Weidland.
When was that?
I'm happy to, if I may approach the bench. Your
Is
Honor.
that from a Jordan? That's it.
Correct.
Okay, I got it. Okay.
Your Honor, also, I have made a number of representations in the bond motion, and I corrected, there was one mistake that Ms. Blanche pointed out, and she's in agreement. I also want to point out one other thing. The two of us went through the guidelines, and on the current offenses, if he was convicted as charges to both of them, we agree that on the low end, it would be 0 to 17 months. On the high end, though, I said, I think 10 to 23, there would actually be 19 to 38.
Got it.
Okay.
Okay.
Your Honor, I understand, and I did listen to the bond hearing, that there is an active homicide investigation going on. I spoke to Mr. Surma at the Wayne County Prosecutor's Office, who is overseeing that investigation. And I've spoken to Ms. Blanche, and she agrees. Here were the representations. The cause of death has not been determined. The investigation is open. There is no timetable as to when that will be completed. And it's not even clear at this stage that there is a homicide associated with the body that was found. I indicated that he is a longstanding member of the community. He has lived in this country for over 40 years, over 40 years. He served in the military and the Marines, and I have a picture, Your Honor, that verifies his service in Marines at Desert Storm. To say that he has community support is a gross understatement. Present, I'll just give a number of people who would vouch for his credibility, for his desire to appear at all of the cases to defend himself on these charges. Again, Mr. Hajar is 57-year-old, a U.S. citizen. He's lived in the Detroit metropolitan area his entire time in the United States, other than when he was in the Marine Corps. He owns his own home in Dearborn, where he resides with his mother, sister, and son and daughter. He has one prior misdemeanor from 2012. That's a DWI, which he received probation and successfully completed probation. He also has an associate's degree from Henry Ford Community College, and I've already supplied the court with a letter from his employer. He does have one prior drinking offense, but there's no indication that at this time he has any substance abuse problem at all. I don't know if the court had an opportunity. I did give the court the URL for the Zoom hearing on all that.
I review all of them whenever I have a motion, so I'd seen it.
Okay, so all he said was he has, quote, the potential for violence. Outside of this offense, there's no history of violence. If he's charged with murder down the road, which certainly is an open question. So, when you're charged, you're presumed to be innocent. You would assume even more so when you're not charged. And that bond can be appropriate. Judge, I'm not asking here for a personal bond, although quite frankly, under the court rules, I don't think a personal bond would be out of order. I'm asking for $100,000 10% bond with a GPS tether. He can only go to work, to medical appointments, and religious services. I think that is an absolutely reasonable bond. There's no history of flight. If the court has questions, I'd be happy to answer
Well,
them.
in terms of the coordination, because this stretches over 2 counties, and you indicated that you talked to somebody from Wayne County.
Correct. As
And maybe Ms. Blanche will answer this, so I was holding off in terms of the question. In terms of the murder investigation, as well as the potential charges, who would have those?
They would be our jurisdiction. So I
Got
don't know why Wayne County would say that it's their jurisdiction, because we actually sat down and had a briefing with Wayne County Prosecutor's Office, Dearborn Police, Northfield. They were present. The body is located in our jurisdiction. So if we can't prove exactly where, let's say it comes back as strangulation or something, it happened on the high, I mean, the jurisdiction would be where the body is.
Body
So
is,
right now,
correct.
we have jurisdiction. If we do declare homicide, it is going to be in our jurisdiction right now. But obviously we are not there yet, but this is an ongoing active investigation.
Well,
And I-
and that just so that you know, and I sorry to interrupt you there, but that's why when you said about Wayne County, I was curious, because it would seem to me that, at least from the sketchy facts that I know, that it would be here unless there was something else.
If-
It would be here.
May I, Your Honor, and I
Yes.
can expand upon that a little bit. We've spoken, and I think she would agree with what I'm about to represent to the court. Wayne County is also involved in the case because they don't know where she died. And we don't know whether it's a homicide, but I spoke to Ms. Blanche and she agrees that it's an open investigation. No charge has been brought. There's no timetable, and they have not even at this point determined that homicide is the cause or the manner of death. So to hold this man on a $2 million cash or surety bond without even know whether it's a homicide and under what circumstances, I think is antithetical to everything that this country stands for, that someone's presumed innocent. He has not been charged. If he's charged, then whether it be in Wayne or Washtenaw County, then the court can set a bond that it believes appropriate for a murder, depending on whether the proof is evident or the presumption great. But the $2 million cash bond on offenses that theoretically the guidelines are 0 to 17 at best, and like I said, at worst 19 to 38 seems to me to be a violation of the 8th Amendment and the Michigan Constitution. If the court has questions, I'd be more than happy to answer, but I don't think I've made any representations today that Ms. Blanche would disagree with in terms of the homicide investigation.
Well, besides, I didn't want to get into the autopsy or what has been conducted so far, because it isn't relevant to the charges yet, correct?
Right.
But the fact that he's making these representations in court, the medical examiners are medical examiner in our jurisdiction, and she did say that the circumstances are consistent with homicidal violence. That is, last time I talked to her, she's still waiting for the toxicology. It's pending. We won't know cause and manner until after that is done, and she wants to, hold off on drafting the autopsy protocol. But that is all we have right now in terms of whether or not this is a homicide. Obviously, it's still being investigated, but I'd like to speak just now based on the charges when I can on why I would like the bond to continue as it is.
And if, Your Honor, homicide charges are brought, I will make sure he surrenders himself.
Yeah, but counsel, if I were to have that preliminary finding, and I realize it's not a finding, but that this is consistent with homicide, and then I have what was, at least from the documents filed by the parties, that there is some connection there. Why wouldn't I take that into account? I mean, what would be inappropriate, I guess, with the court taking that into account?
what I think would be inappropriate is that he hasn't been charged and he's presumed to be innocent. But let's assume that you can take it in. I think a $2 million cash or surety bond is still excessive. I mean, I'm not, like I said, I'm not asking for a personal bond. I'm not asking him.
Yeah, but counsel, what I'm getting at is you're indicating to me that there's no determination that it's a homicide.
I was not aware that there was a preliminary finding.
Right. I understand. I'm not saying that you're trying to misrepresent anything to the court. That by no means am I saying that. What I'm indicating, though, is that you want me to take into account sort of the absence of something where there's something going on and I now have something else, but you don't want me to take that into account. And I don't know that courts operate that way.
Okay. So let's take that into account. Then I think a $500,000 10% bond would be reasonable, but a $2 million cash or surety bond, it's no bond at all. And even on a homicide, bond may be denied. There's a recent Supreme Court case, bond may be denied where the proof is evident of the presumption great, but does not necessarily have to be denied. You can get a bond on a murder case where the proof is evident and the presumption great. It's permissive as to whether you remand somebody. But on the charges that he's facing now, he's entitled by the Constitution, both of Michigan and the United States, to a reasonable bond. And for a case.
So I'm hearing you, but I'm just saying the idea of what's going to be a reasonable bond is in a lot of ways also, you certainly laid out the factors in your brief, but it's also the circumstances and sort of context that I'm operating in as to what the reasonableness of that bond is. Okay. I mean, certainly that has to be taken into account. This becomes a different type of case in certain respects because there is this ongoing piece of it.
I certainly understand where the court is coming from, but if the court does not feel my suggestion of $100,000 10% bond is reasonable, then the court can set some other bond, but $2 million cash or surety, no 10%, I just think is far excessive given that what he's facing now carries under the guidelines, in worst case scenario, 19 to 38 months.
Okay. And I'll certainly let Ms. Blanche argue, but one of the things that I'm to understand is that there is, so a couple of things. One, that there may have been misrepresentations as to the knowledge of the individual to the police by the defendant.
That's been an accusation. I have not seen any discovery yet, so I can't speak to that. But I know that's been represented by, I've been told that there was a false exculpatory statement made. I'm aware of it.
Correct. And also the, I guess, the phone tracking data, which is also present. So, and my point to that is this, and I don't know how much of the discovery you've seen, what you've seen, or
none.
Or not. When you're telling me you haven't seen any, then I don't know what I necessarily do with that. But as I'm to gather from this, were this a circumstance of he knew the person or saw the person, shot with the person, nothing else sort of connects them there, and then the person a week later is found dead, I certainly get your point. I don't think that's what I have here, which places this, at least for me, in a different posture. Because and I'll certainly let Ms. Blanche give the argument and the information to the court on that. But from what I gather here, I have, I think, his phone in the township, in Northfield Township. I have, so he's sort of tracked to where the body is.
That's my
And-
understanding.
And
The
also,
bond hearing.
well, right, but then also that there is video where the defendant is in the presence of the decedent in this case. So it certainly, I'm not operating in the vacuum you'd like for me to operate in, because I think I've got something wholly different here. Now, there may be other explanations for it ultimately down the road. I'm not making that type of finding, but I can't leave that out and just ignore it either.
Okay. I get that, Your Honor. That's why I'm saying if the court doesn't feel $100,000, 10% is a reasonable bond, then the court has a variety of bonds, $500,000, 10% bond, $1 million, 10% bond. But a $2 million cash or surety bond is no bond at all for all practical purposes.
Okay. All right. Thank you. Ms. Blanche.
Judge,
Your Honor.
Oh, I'm sorry. Was there?
However, the court's most comfortable. I just want to just add a piece.
Yeah, then I'll let them go first. It's your motion, so go ahead.
Your Honor, I would just argue that the factors that the court's relying on, what's been placed on the record, I still don't think is a nexus with a homicide charge. I think with count 1 and count 2, that's what the court's laying on the record here, is that if someone was allegedly found in a certain area, but there's been nothing placed on the record that tells us there's a certain dispute or certain violent tendency, certain behavior that my client is responsible for this. That has not been laid on the record. What's been laid on the record here is supporting evidence for count 1 and count 2 of this charge, not of any unrelated charge. There's been nothing before us that said that there was some sort of issue.
So let me just stop you there for a moment, because there's a bit of a problem here.
Why is that?
Because yes, that's what you're dealing with at this point. But I think that goes to then ignore the fact that there is this continuing investigation into a homicide. And then with the information, just the brief information that was presented by the people, that what they're, at least the medical examiner is seeing, is something consistent with a homicide. So, and I'll let you finish your argument, but I want to make sure that you understand how I'm seeing some of this, and that is that if on the surface of it, something is consistent with a homicide, and then I have not just the defendant in the presence of that person, but then I have tracking data that would place him in the township near the body, I'm looking at something totally different. I get what you're saying in terms of the charges, but that becomes problematic, I think, from the court in terms of the setting of the bond and release conditions, because this is something that is fluid. So go ahead.
And ultimately, just to finish off, Judge, I don't see that anything's been placed on the record, despite everything that's been placed on the record, that a GPS tether, any sort of confinement provision with that 100,000, 10% would not be sufficient to protect any community. I mean, he's hired attorneys. He's going to be confined to his home. He's going to have to put up money. I mean, we have almost this entire community here behind us. We have his 87-year-old mother who lives with him, who he's caring for. He has his 2 children. I mean, his ex-wife, I've never seen an ex-wife come and support any of my clients, Your Honor, in court. So I think we have the community.
You just don't know the good ex-wives. Go ahead.
My ex-wife came to my
I don't know.
my ex-wife came to my second wedding.
And just to finish this off, Judge,
Yes.
I'm not sure how many times the court hears this, but I've met with Mr. Hajar. I've met with his lovely family. I really, really think that this is an amazing person. I think he's going to adhere to any of your conditions. I understand that there's a serious situation going on, but as it relates to bond, I don't think that anything's been placed that tells us he's going to violate a confinement provision or that he won't surrender his passport. He's willing to do all of this, Judge. And we have no problem with him doing this confined to his home and paying at least $10,000. But I'd ask the court to just keep that in consideration when ruling on bond.
All right.
Thank you.
Ms. Blanche.
Judge, obviously the victim is deceased in this case. This was called in as a missing person. Her last phone location was at the defendant's house. They went to go question the defendant. He said he doesn't know who this person was. And then they started gathering his coordinates of his phone along with video. And based on the video, the victim's last seen going into his house, she never leaves. His car at, I think it's early in the morning, you see his car lights come on, off, and then you don't see the defendant leave his home until later the day when he tracks up to Northfield Township, and her body is located in the place that his phone coordinates and his car, there's video, different places up in Northfield Township where he's roaming around, and her body is then discovered a week later. So she's last seen going in his home, she never leaves, and then her body is recovered a week later up in Northfield Township. I think there's huge grave concern for the community safety. He's been dishonest with police. He acted like he didn't know her. Then he said, oh wait, yeah, I do know her. She was at my house, but she left earlier in the morning. So there is concern for community safety. And the fact that on the records in place, well, how do we, a GPS tether would be sufficient here? That GPS tether would tether him to the home that this allegedly took place at. The fact that we have a missing person that was last seen in his house. So we have a GPS tether at that house with also, he lives with his mom and his kids, who his mom, I believe, was present at that time. So you have witnesses, possible witnesses, that haven't come forward to the police or even been honest in this, and we want to tether him to that house. Judge, I'm sorry, but there's a huge issue and a huge community safety based on misrepresentations by this defendant, and then also the circumstances surrounding this case. So no, I'm asking you to continue the bond, the $2 million bond. I believe it's reasonable under the circumstances. I was asked for a $10 million bond. If this was a homicide, I would ask you to deny bond. But we are asking for a bond. We're not asking you to deny bond. That's not appropriate under the court rules. The $2 million, yes, according to community safety, I believe it is. It is.
Just briefly, Your Honor, if the court thinks he shouldn't reside at his own home, maybe we can make arrangements that he could live with one of his friends, his brother, or a close friend. Right? So there was a Detroit police officer who's known him since high school. I'm not saying, Your Honor, again, I don't want the court to misunderstand my argument. I am not saying that you shouldn't at all take the homicide investigation into consideration. What I am saying is, even if you take it into consideration, he hasn't been charged with it, and a $2 million bond is no bond at all. I mean, if you wanted to go to a bail bondsman, you'd have a $200,000 premium that would be non-refundable. They don't have that kind of money. So again, maybe he can raise some money with friends and family. He's obviously got a lot of support, but it ought to be some kind of a reasonable 10% bond. That's all what I'm asking.
But Counsel, you would agree that the reasonableness, I mean, one of the things that you're arguing to the court is that he's not a danger to the community. Correct? I mean, no, go ahead.
I don't think that's not the standard. The standard is, are there reasonable conditions that can assure the safety?
It's a huge factor. Counsel.
It is.
I mean, that's a huge factor.
It's an important factor. There's no question. But the question are there conditions that can be imposed that would mitigate that danger to the community? Nobody can say anybody is never a danger to the community unless, possession of.
Okay, but Counsel, maybe you're not following what I'm saying. What I'm saying is this. If on the one hand, and I just hypothetically place an extreme out there of, I guess the extreme would be, in my mind, what the prosecutors laid out in terms of the woman goes into the house, she never comes out. He is seen leaving. We have his phone then in Northfield Township. We have her phone at his house, so we know that they're at some point together. That's one extreme. If on the other extreme, I just have, okay, she was at his house, but at some point she left, her phone is someplace else or goes someplace else, and then something may have intervened that happened differently, you'd want me to take that into consideration in terms of setting bond, because that would cut against him being a danger.
I don't want the court to think that I don't think that danger to the community is not a relevant factor. I hear the court completely. I've been doing this for 44 years and I get where the court is coming from. My point isn't that danger to the community shouldn't be considered. My point is that the bond that is set is unreasonable. And you can consider in determining what the appropriate bond is. It doesn't need to be a $2 million cash or surety bond.
But counsel, maybe you
A $2 million 10%
maybe
bond.
you agree or disagree with this, but the reasonableness, especially if I were just using the one factor of danger to the community, the reasonableness of that bond that I may set is certainly going to be dependent in some way with the risk that I see.
Correct.
Right?
I agree with that.
So it really requires me to sort of analyze what's there and what risk is there. I never forgetting he's presumed to be innocent. I'm not saying that, but just in terms of the risk of what evidence is there. I'm having a difficulty here at this particular moment. And because I don't want to, I want a full fair hearing for anybody that comes before me. But when you indicate to me that you haven't seen the discovery in some of the stuff that's coming out, and I'm not saying anybody's playing any games, I'm not saying any of that. I would just like the full-fledged argument. There may be a reason, if true, and I have no reason to doubt it, that her phone tracks to his house, which may be inconsistent with statements that he's given. There may be some reason for it. And I don't, where I'm at right now, and I understand why you brought the motion when you did, but where I'm at right now is that gets put out there. I don't have anything on the other side of that. And there may be, and it may be unfair for me to be looking from that, from you, if you haven't seen even the preliminary parts of the discovery.
The only thing I know is what I listened to at the arraignment and the bond hearing at the arraignment. But let's assume if let's say this was a murder, which it's not at this stage, and the cause and manner of death have not definitively been determined, I think a $2 million 10% bond would be reasonable. So what I'm saying is the court should not have to punish him and make him pay a premium of $200,000 that is not refundable. So make it a 10% bond, Your Honor.
I don't think this court gets in the business of punishing people with bonds. We just don't.
But again,
but counsel, some people, sometimes the prosecutor thinks maybe the court's being too lenient. We're letting people go because of the bonds that we've set. Then there's defense attorneys that get all upset with us saying we're trying to punish people by the bonds that were set. I can tell you every judicial officer in this court, and I know certainly for me, I'm looking at a number of different factors. I rely upon counsel to give me all of those factors. I factor in all of the things that you pointed out. Factor in, is this person going to be a danger to the community? Is there a way that I can, given the circumstances of what's going on, safely release this person into the community and the like? I go through that whole analysis.
Can I throw something out to the court that I think...
Can I stop you? Probably not.
You probably,
go ahead.
If you told me no, I would keep my mouth shut. I can tell you that. I've learned. Judge, the difference between a $2 million cash or surety bond and a $2 million 10% bond, the only difference is either way he has to put up $200,000. Either way he has to put up, but one is refundable and one is not. And even the $200,000 10% bond, the court keeps $20,000 of that for administrative costs. So all I'm saying is, Judge, if you're going to make him post $200,000, if he shows up, which is certainly isn't chump change, $200,000, that is a significant bond, and he forfeits it if he violates it in any way. And if the court feels that he should live with his brother, who would ask as a third-party custodian, so be it. But I'm asking, Your Honor, that all I'm saying is, even when you consider the homicide investigation, that a $2 million cash or surety bond is excessive. That's my argument, Your Honor. And whether,
Well, you just said two things to me, because I'm trying to figure out, and I want to make sure I'm getting your point. I understand you're saying that it's excessive. You're also making the argument, I think, that even if the net dollar amount's the same, that when all's said and done, somebody, whoever would put that up, would like to get some of it back.
well, the bail bondsman doesn't get it back.
Oh, I know. I am aware of that.
But also, the difference is that he could possibly raise $200,000 with the understanding that he's going to show up. These people trust him. They would loan him the money. But with a bail bondsman, he'll never see it again. And nor will the friends and family that are willing to chip in to post a bond. He does not have $200,000. So I just don't think, Your Honor, what I'm requesting is unreasonable to make it a 10% bond. I mean, it's obvious this court is not going to, I've been doing this long enough, not going to follow my recommendation of $100,000 10%, although I don't think it's unreasonable, but at least make the bond as it stands a 10% bond, or make it $1 million 10% bond, or somewhere in between. That's my argument, Your Honor.
Judge, can I just put one thing on record, that discovery is available. They just need to request it from our office. It's been available since I had written a warrant. So I didn't want to make it seem like we were withholding discovery and they couldn't look at it prior to this honor. I mean, I don't think you're making that. I'm just wanting that in the record so that like it is available, so they can just request it from our office.
He said he did request the investigators report, but he hasn't gotten it.
I did email you for the investigators.
PA discovery?
I emailed your personal email.
No, you have to do.
No.
Okay. Anyway, Your Honor, that's the argument. I just think that at a minimum, the court should make this a 10% bond. At a minimum. I mean, I've been doing this for 44 years, shown this kind of support at a bond hearing, ever. I mean, he's got strong ties with the community, served his country honorably, put his life on the line in Iraq.
Counsel, I'm not disputing any of that.
I know you.
That's what it is. I also realize I have people who may have led great lives, that when one's looking at it, they've led great lives, that all of a sudden something happens. Don't know what, maybe nothing happens, but all of a sudden something's in front of me that something has happened. And at that point, I have to sort of weigh and balance and try to determine what would be appropriate to have this person released.
Understood.
If I have someone who on one hand met somebody that night and then somehow or another through nothing that really connects them ends up deceased someplace in the field or wherever, that's one thing. If I have someone who, and I'm not saying this is his case, lured somebody into a house and then all of a sudden kills them and then it takes them out and then dumps them into a field, those things on the surface can look the same, but it's a very different risk analysis in terms of what bond I set to then let somebody into the community.
I understand. Again, I'm not asking for some.
No, I know, counsel, and
But I think his 57 years should count for something, just as a homicide investigation should.
It does. His service to this country, it counts. The support, everything counts. It's a balancing for me. I appreciate the support that's come. I appreciate all the letters, everything that I've seen. All of those are things for this court to weigh. But there's something going on the other side of the scale too. I can't just take that and say, okay, well, this is it. There's something on the other side of the scale, which the people have pointed out. And the problem, counsel, and this is where I want fairness, is that those things that the people are putting forth, I don't have a count. I'm not hearing a counter from you.
The counter is, Your Honor,
Well, hold it, counsel. I'm not saying, no, what I'm saying is this. I'm not looking for you to give me your whole case.
No,
I'm not
I
looking
wasn't.
for you to do all of that. All I'm saying is what the people have laid out, quite frankly, is some pretty damning things if those allegations are there. And I'm not hearing an answer. I'm not saying that I won't have an answer, but I'm not hearing an answer. And I think the reason I'm not hearing an answer, or even some suggestion of an answer, is because the discovery hasn't been seen.
My answer wasn't going to be on the merits of the facts of the case. My answer was going to be, the court said, yes, his life does count for something. And
Absolutely.
so if that counts for something, and the homicide investigation also counts for something, which clearly this court believes, and I'm not going to challenge that at this stage. So they both count for something. So if they both count for something, there's somewhere in between a $2 million cash or surety bond and a personal bond.
Well, that's funny, counsel, because what I would really be arguing in between is what their original request was, which was a 10 million and a personal. So I'm not here to just pick a number. I really, that's not what it is for me.
I understand
This
that.
is not, setting bond is not a science, it's an art.
Right.
So it's tough to do.
Right. I'm not trying to beat a dead horse, Your Honor. All I'm asking is that the $2 million bond, he simply cannot make. So if the court made it 10%, there'd be if he can raise that, then he'd have to raise $200,000, which is certainly, as I said, not chump change. It's a significant bond. And I think given that he has not been charged with a homicide, but considering that that's something that is in your calculus, that's a fair and reasonable bond. That's my argument, Judge. And given his long life history that anyone would be proud of up until these charges, that is worth something. And what it's worth, in my estimation, is a reduction of the current bond.
Counsel, let me ask you. Okay. I have her phone tracked to his house.
Correct.
I have his phone tracked to the location of her body. What would you have me do with that? I'm not saying any of that can necessarily be proved, but what would you have when you're talking about me doing the calculus? What do I do with that?
You consider that down the road, perhaps there could be homicide charges of some sort, whether it be murder or manslaughter, and that be taken into consideration and is a factor. But there are also other factors that I think can assure conditions or combination of conditions, meaning tether, passport, third-party custodian, that will assure the safety of the community. So again, I didn't ask for a personal bond in this case. I didn't even ask for a $50,000 10% bond. I asked for what I thought was a significant bond, but obviously the court certainly does not agree with that. And so what
and counsel, I'm wondering, and I know you're advocating for your client, I'm wondering whether or not you would agree with that if you saw at least the preliminary discovery.
What, a $2 million bond?
Well,
I would,
with something other than what you placed in your motion. And I don't know, counsel, and I'm not trying to put you on the spot in that. I'm just saying,
if and when he's charged with a homicide, he could be remanded.
But counsel, let's say it's not even the homicide charge. But I have those factors all in the charges what I have now.
Correct.
That's a huge risk.
anytime someone is released on bond, there is a risk, Judge.
Yes, but counsel, there are different cases.
That's
And
right.
if I have some woman who has disappeared, who ends up dead, who the phones are at the same places, and then within the course of that investigation, I have someone that you want me to let out to say, trust him that he will do this, and I look at his life, I also have that other part that he's been deceptive throughout the investigation. All of that's got to play in.
Judge, I don't know, maybe I'm not making myself clear, but what I keep saying the same thing. Yes, if you want to take that into consideration, I understand that. My argument, Your Honor, is that if there's going to be a $2 million bond, it ought to at least be a 10% bond. And that, I think, is a reasonable bond. I've seen homicide cases, murder cases that I've done in my 44 years, and I've done nothing but criminal defense my entire career, where I've seen in homicide cases bonds far less than a $2 million 10%, where there's significant evidence. So what I'm saying, Your Honor, is what's reasonable. And what I'm arguing is a bond that one can't make is not reasonable, particularly where he hasn't actually been faced with, it's not charged with a homicide. So again, I don't want to lose credibility with the court. So I get the message clear. It's come through clear that the bond I've requested is not in the cards. But I think to have this bond where it's at and just make it a 10% bond where the same $200,000 is posted is reasonable and fair, taking into the facts and his life.
So counsel, if I set it at $500,000, 10%.
I don't think that's $500,000, Judge.
Oh, I can do math. Yeah, I get it.
That's, can I speak with the family for a minute, Your Honor?
See, this is the issue, because he's saying this is not a reasonable bond, but he also in the same breath says it would be reasonable if it wasn't a surety so they could get the money back. So we can bring them, we can provide the money to release him, but we want it right back, so that's why it's unreasonable. So he does have access to the funds clearly to be able to actually pay the bond. So in this whole reasonable thing, there's no case law that counsel has applied to this court saying that this bond that's been set by the magistrate was unreasonable from the start. So at this point, Judge, I don't think the magistrate was acting outside its authority unless there's some law that can be provided. But based on the circumstances and the argument, I don't know how you are unreasonable at this point. Now it's just whether or not how we're going to pay for the bond.
Judge, my law is the 8th Amendment to the United States Constitution that buy-in should not be excessive. Judge, again, I do think, and I know this, I've appeared before Your Honor, not a whole lot of times, but a few times. We had a case, I don't know if the court will recall, where it went on for a year before it went from district to circuit court.
Yes.
But I am confident. I mean, we have all of these people who are reputable people in the community. His employer, knowing that he's being investigated, said he can have his job. If the court wants to confine him to his home and not let him work, so be it. But to sit in the Washtenaw County Jail, given his background and history, where he has not even been charged yet with a homicide, I think just a $2 million cash or surety bond is excessive. I'm just repeating myself.
No, I know.
And
I will give you time to talk with the family. I'll take a recess.
Okay. Thank you.
Let you know.
All right. The additions to the second session, the Honorable Judge J. Cedric Simpson presiding.
May be seated.
Judge, thank you for giving me the opportunity to talk to the family. There's 2 points that I thought of that well, the first is Ms. Blanchard was kind enough to forward
Ms.
the
Blanche, you mean?
But did I say Miss Blanche? I'm
Yeah,
sorry.
you made her like the ex-governor.
The ex-governor. Right.
I don't know. Go ahead.
Anyway, she was kind enough to forward me the email that she got from the medical examiner.
Okay.
And what it says, yes, it does say a skeletal trauma, and it says A skeletal trauma analysis will be performed this month. Toxicology is pending. The circumstances are consistent with homicidal violence, but the body may not give a definitive cause. So it would seem to me, Your Honor, that if there was blunt force trauma, that would have been seen immediately to the skull. And I don't know what she means by the circumstances, but
Counsel, I think we need your client.
Oh, I'm sorry.
No, you just broke into argument. And I
Okay.
thinking he probably should be here for this.
Shall I go get him?
No, you can go get him, but
But I don't think-
they'll probably keep you. No, you can't get here.
And I appreciate the court's infinite patience.
Sometimes it's all I have. Because you are better. Go ahead, counsel.
Okay. Again, Ms. Blanche was kind enough to forward me the email she received from the medical examiner. And it says the body may not give a definitive cause. And it says toxicology is pending. I mean, this could have been an overdose. We just don't know. But what to me is important is that the skull she was able to examine, and there's no statement in here that it was the result of any kind of blunt force trauma. The second thing I wanted to make a point of, which I think is really, I thought about this after the court granted us a recess for me to talk to the family. I think on one level, having to borrow money from friends and family is more a guarantee of an appearance than if you paid a bail bondsman, because this is his family, and he'd be letting down his friends and family that are willing to post the bond because they have faith in him. I don't know that I really fully understood, or at least I thought I did, but did the court ask about a $500,000, 10%, or $5 million?
Well, you were making the argument about getting money back and the like, and sort of balancing that against the something to guarantee his presence. And at least in my mind, that's what I was
certainly,
and so that's what I put that out there as you were arguing about the payment of the $200,000.
Anyway, if the court was inclined to raise the bond to something higher than $200,000 with a 10% provision, that would certainly be less onerous than a $200,000 cash bond. But again, the bond I suggested, which the court obviously doesn't agree with, I thought was reasonable, but even it's going to be difficult. They don't know whether they can post a $500,000 10% bond. They would certainly try, but I think they could post a $2 million 10% bond. So with that being said,
that they could post a $2 million if it were
it would take some. Pardon?
If it were 10%,
Yes.
it could be posted.
Yes, the family they think they could gather enough money from friends and family to post that kind of a bond. And like I said, I think it is more of an assurance if he's indebted to his friends and family than to a bail bondsman who he has no connection with. And I given, that they may never be able to tell the cause of death. And certainly I understand where the court's coming from, that this could be a homicide. And if it is, then obviously the bond may change, but it's not there yet. And, in this country, we are presumed to be innocent. So I think the $200,000
Counsel, believe me,
I know you do.
that is not,
You just are worried about
it
the
is
danger.
not lost on the court.
I know.
That whole concept is not lost on the court.
Okay.
But what also is not lost on the court is the other pieces that are there that aren't necessarily being argued. I understand it hasn't been charged. I also understand that people can't charge a case until they have enough there to charge. But there are,
But I've
it's
conceded,
the
Judge.
fluid nature of the information that is causing the court some consternation, because this isn't, I have an event. We pretty much know everything about that event. and we're done. What I have here is we have an event of some type. We're not even sure what that event necessarily was, but we see some of the manifestations of it. And then there are pieces filling in, like the phones,
Right.
and those kinds of things that.
I get it. And Judge, I want you to understand this. When I made this bond suggestion, if it had been in a vacuum and there was no evidence that this could be a homicide, I would have not asked for $100,000 10% bond. I would have asked for a lower bond. So it wasn't like it was lost on me.
No, I know.
You know, that's why I didn't ask for a personal bond, because I do understand how the court might want to consider that there's an open homicide investigation. But again, my point is not that it's irrelevant, because I don't think it's irrelevant, and I don't think I've ever suggested that it's irrelevant. But what I do think is that it's relevant, but so is the life that he has lived that anybody would be proud of up until this point. And so again, if it's a $2 million 10% bond, the family thinks they could raise that. If the court thinks that a higher bond of a 10% is necessary, obviously we have to defer to the court. But I do think the $2 million cash or surety bond is just not reasonable and is excessive in violation of both the Michigan and the United States Constitution. And thank you for your time, Judge.
Thank you. Ms. Blanche, anything else?
I feel like I'd just be belaboring all the points I made before, but I am, like I said, concerned with community safety based on the fact she was last seen with him. She's found dead and he's tracking up to Northfield. That's a huge concern. And even if it came back that she overdosed, he didn't even call. If that was, let's say that was the benefit of the doubt for best case scenario. He didn't call for medical. He did nothing. He dumped her body on the side of a road up in Northfield Township in our jurisdiction. So even if that was the case, nothing was done to help this person that was in his supervision at that time that he was with her. So even if that was the benefit of the doubt and that was the argument, that's what comes out, that's still, I mean, the fact that you're lying, making distress representations to the police, lying to the police, and then this woman is found dead in our community. Honestly, Judge, a $2 million bond is not unreasonable under the circumstances.
I believe we are set for a PCC next week on the 25th. Okay, here's what I'm going to do, and I'm doing this for a reason, mainly to inure to the benefit of the defendant in this case. I've heard the argument here. You can supply me whatever other information you want to supply to the court. I'm going to make my decision. I'm going to move the PCC to 3 o'clock on the 25th, if that will work with counsel's schedule. I will also set my decision on your bond motion for that same time. I want to mull over some things. I want to look at it. I'm doing that, and usually I don't adjourn my decision on bonds to another date. I will usually make that decision, but I want to look very closely at some things. I also want defendant to defense counsel to at least get a preliminary look at the initial discovery that's there, so that and have an understanding of what the court may be taking into account with what the people have presented. So that's what I'm going to do. I don't, like I said, I'm not accustomed to doing that. And if I felt that absolutely the magistrate's decision on bond was an absolute abuse of discretion, I wouldn't hesitate to rule immediately. But I can't say that in my mind at this particular point in time with what I see. But I want to give you a chance to counter some of what the prosecution has put forth. I don't think that can be countered without seeing that discovered. Go ahead.
I appreciate, the court taking the time to really, give serious to consideration. I don't know that once I see the discovery, that I'm going to have any answers. I'm obviously not going to put forward a position factually at this early stage of the case.
Correct.
But what I would ask maybe is if the court would consider lowering the bond to something that you suggested earlier, and then if I can supplement it, I will do that. But I'd like to give him the opportunity, at least at this stage, to try to raise some kind of a bond. So if the court would be willing to entertain that possibility, looking at it in the light most favorable to the prosecutor, set some kind of other bond that is currently set, and then if I can convince the court that
I don't think you, counsel, I get what you're saying. I don't think you want me taking what I know now, looking at it with benefit to the prosecution. I really don't think I understand why you're saying that to me, but I don't think you want me to do that, because if I do that, I'm done. And I don't think I should be, because I want to make sure that everything that you have is given to me, and then let me make my ruling. Like it, dislike it. But the one thing that you'll be able to say is that I looked at everything, gave everybody the opportunity to put forth everything before me, before I made my decision. And that's why I'm doing it this way.
Okay.
All right.
Thank you.
So the 25th at 3 o'clock
if the
will
court
be the probable cause conference, as well as that. Let me also ask this, Ms. Blanche, you may or may not know. There's additional evidence that obviously an investigation that's proceeding. Is there anything that's going to be anticipated is coming forth within the next week that would be relevant to this particular?
I can't speak to, I would have to, obviously, I know I've actively been reviewing search warrants just like today I have, so there will be stuff coming in. I don't know within the next week what we will have.
Gotcha. Okay.
I think the most important thing, Your Honor, at this stage is the autopsy.
Well,
cause of death.
Correct. But in terms of my determination as to whether or not this individual poses a danger to the community or not, I think that there are other factors that may come in that may play into the court's decision that I don't know. Okay.
Thank you.
Thank you. Yes, it was.
Okay. 25th at
Your
3
Honor,
o'clock.
I filled out a handwritten appearance, but I had to cross out some numbers. So can I just file a typewritten?
You did not file an appearance?
I have it with me.
Well, hold it. Didn't we have him on the case?
I've been corresponding with Ms. Weidman. I have it here.
It's handwritten? Can we?
And he's been on the case.
And you've been on the
Yes,
case,
correct.
so
He
it,
has his representation from.
counsel, if it's handwritten, as long as I can read it. If you write like a doctor, I'm going to have a problem. But if I can read it, I'll take it. All right. You don't have to go back and type it. Okay. But yeah, that will be fine if it's handwritten. Okay. Anything else from either side? Okay. So at this time, bond will continue pending the hearing on the 25th.
Thank you, Judge.
All right. And folks in the courtroom, thank you very much for the manner in which you conducted yourselves. The court does very much appreciate that, that everybody behaved. All right. Thank you.